When religious freedom collides with the right to life, which prevails? Today we break down the Supreme Court's hearing on female genital mutilation, the Sunita Tiwari case, and why Articles 21, 25 and Article 14 are at the heart of this debate. Let's understand what is female genital mutilation. Female genital mutilation involves the partial or total removal of external female genitalia or other injury to female genital organs for non-medical reasons. Types of female genital mutilation: clitoridectomy, removal of clitoris; excision, removal of clitoris and labia; infibulation, narrowing of vaginal opening. It affects are severe pain, infections and complications in childbirth, long-term psychological trauma. Now let's understand its genesis and practice in India. It originates in African and Middle Eastern traditions justified as a purity or control of sexuality. In India, practiced mainly among Dawoodi Bohra community, often on girls around age 7. No child can provide informed consent at that age, making it a violation of dignity and bodily autonomy. Let's discuss the case Sunita Tiwari vs. Union of India 2017. It was filed in the 2017, now before a 9-judge bench in the April 2026. A petitioner seeks to declare female genital mutilation unconstitutional, demand a specific anti-female genital mutilation law, and ensure prosecution under existing criminal laws like IPC, CRPC, POSCO, and the Bharatiya Nagarik Suraksha Sanhita and Bharatiya Nyaya Sanhita. The core question is, does Article 25 religious freedom protect female genital mutilation, or does it violate Article 21 right to life and dignity and Article 14 right to equality? Let's understand the Supreme Court precedents on similar issues. In Sabarimala 2018 verdict, review was ongoing currently. In that court held exclusion of women unconstitutional, emphasizing that essential religious practices must be tested against equality and dignity. Maneka Gandhi vs. Union of India 1978, in which court expanded Article 21 to include dignity and personal liberty. Shera Banu vs. Union of India 2017, Tribal Talaq struck down as unconstitutional, showing religious practices cannot override fundamental rights. Now let's understand the legal framework governing this issue. IPC and POSCO. Female genital mutilation can be prosecuted as grievous hurt, Section 326 IPC, and sexual assault on minors under POSCO. Bharatiya Nyaya Sanhita 2023, which replaced the IPC, retains provisions against bodily harm and sexual offences. Bharatiya Nagarik Suraksha Sanhita 2023, which replaces CRPC, governs investigation and trial procedures. Thus, even without a special anti-female genital mutilation law, existing courts criminalizes the practice. In 2017, the Minister for Women and Child Development, Maneka Gandhi, stated that female genital mutilation is a criminal offence. If the Bohra community does not stop it voluntarily, the government will bring in a law to ban the practice. Common questions about female genital mutilation we get as the general public. Can a woman get pregnant after female genital mutilation? Yes, but complications are common: obstructed labor, infections, higher maternal mortality. Does female genital mutilation reduce sexual desire? It causes trauma and pain, often reducing sexual satisfaction. Is female genital mutilation legal in India? No, it is prosecutable under IPC, POSCO and Bharatiya Nyaya Samhita. Is it an essential religious practice? Courts will decide, but precedents like Sabarimala and Tribal Talaq case shows that harmful practices cannot override fundamental rights. Key parallel case we can quote here is Dadaji Bhikaji vs. Rukumbai 1885, which is a famous case in the Indian history in which a minor girl married without consent. When she became a major, she refused cohabitation with her husband, and the court upheld her right, stressing that consent of a minor is invalid. So we can understand the parallel to the female genital mutilation here. A 7-year-old cannot give informed consent to a permanent harmful procedure. Key suggestions for strengthening democratic rights. First one, explicit anti-female genital mutilation law that could criminalize the female genital mutilation with clear penalties. Second, child consent protection. Reinforce that minors cannot consent to irreversible procedures. Third, awareness campaigns. Educate communities about health risk. Fourth, fast track trials. Special courts for female genital mutilation cases. Fifth, constitutional morality emphasis. Ensure Article 21 and Article 14 prevail over harmful practices under Article 25. The Supreme Court must decide, does Article 25 protect harmful traditions, or must Article 21 and Article 14 safeguard dignity and equality? Just as in Sabarimala and Tribal Talaq, the answer will shape the future of constitutional morality in India.